The laughter started before she had even reached the council table, and it was the kind of laughter that is meant to be heard. Not hidden, not muffled behind a polite hand, but projected, performed, delivered with the full confidence of a man who has spent 30 years believing that courtrooms belong to him. Richard Ashford, senior partner at Ashford, Bell and Whitmore, stood near the defense table in a charcoal suit that cost more than most people's monthly salary, and he watched the young black woman in the modest navy blazer walk down the center aisle of courtroom 4B, and he decided, in the span of perhaps 2 seconds, exactly who she was and exactly how little she mattered. She carried a slim leather portfolio. She wore flat shoes. Her hair was pulled back simply, and she had the unhurried walk of someone who was exactly where she was supposed to be, which Ashford, in his certainty, read as the aimless wandering of someone who was lost. He turned to the junior associates flanking him, 3 young men in nearly identical suits, and he said, loudly enough for half the gallery to hear, "Looks like the intern pool is sending them straight from orientation now. Sweetheart, the clerk's office is down the hall. This is a federal courtroom, not a field trip." One of the associates laughed. The other 2 smiled the careful, calibrated smiles of men who have learned that laughing at the senior partner's jokes is not optional, merely graded on enthusiasm. A few people in the gallery shifted uncomfortably. No one said anything. No one ever does, not in the moment, not when the man doing the talking bills $1,100 an hour and has a reputation for ending the careers of people who embarrass him. The woman stopped. She looked at Ashford with an expression that was not anger and was not hurt. It was something quieter and infinitely more patient, the expression of someone taking a careful, detailed measurement. She said nothing. She adjusted the portfolio under her arm and continued walking, past the council tables, toward the front of the courtroom, and Ashford, misreading her silence as embarrassment, could not resist a final shot. "If you're looking for the coffee machine," he called after her, "the interns usually figure that out by week 2. Her name was Danielle Hayes. And in approximately 11 minutes, Richard Ashford was going to hear that name announced in a way that would drain the color from his face, scatter his prepared arguments like papers in a wind, and begin the single most catastrophic day of his professional life. Because the case on the docket that morning, a $200 million corporate fraud action that Ashford's firm had spent 14 months maneuvering toward this exact courtroom, was about to be called to order. And the judge assigned to preside over it, the judge whose reputation for precision and preparation had made seasoned litigators rewrite their briefs 3 times before filing, the judge Ashford had never bothered to look up because he assumed all judges could be handled the way he handled everything else, was not running late. She was walking right past him. This is the story of what happens when a man spends 3 decades mistaking arrogance for instinct, when an entire legal machine built on intimidation collides with the one person it cannot intimidate, and when the woman dismissed as an intern turns out to hold absolute authority over everything that man came to win. It is a story about assumptions, about the specific and expensive blindness of people who have never once been required to question their own judgment, and about the peculiar, surgical justice that unfolds when someone with real power decides not to raise her voice, but simply to follow the rules, every rule, to the letter. Danielle Hayes had not planned to walk through the public entrance that morning. The judge's private corridor was under renovation, a mundane fact of building maintenance that no one could have predicted would matter. So she had come in the way everyone else did, through security, down the marble hallway, past the benches of waiting attorneys, dressed not in her robe, which hung in her chambers, but in the plain navy blazer she had worn to work for years, because Danielle Hayes had never in her life felt the need to dress like power in order to hold it. She had, however, learned everything she needed to know about Richard Ashford before he ever said a word, because this was not the first time Danielle Hayes had encountered Richard Ashford. He simply had no memory of her, and that fact, that precise and telling gap in his memory, was itself the whole story in miniature. 19 years earlier, Danielle had been a second-year law student sitting in the offices of Ashford, Bell, and Whitmore for a summer associate interview she had earned with a transcript that placed her in the top 3 of her class at Georgetown. She had prepared for 2 weeks. She had read every major case the firm had litigated in the prior decade. She had walked into that interview room with answers to questions they hadn't thought to ask yet, and she had sat across from a younger Richard Ashford, then a newly minted partner with a rising reputation, and she had watched him glance at her, then at her resume, then back at her, with a small flicker of surprise he did not bother to conceal. The interview lasted 11 minutes. He asked her no substantive legal questions. He asked whether she thought she would be comfortable in the firm's culture. He asked where she had grown up, and when she told him, he nodded slowly, as though a private theory had been confirmed. He spent the final 4 minutes telling her about the firm's mentorship program for candidates from non-traditional backgrounds, a phrase he deployed while looking directly at a transcript that outranked those of the last 5 associates the firm had hired. She did not get the offer. The offer went to a young man whose father golfed with a name partner, a young man who would be quietly asked to leave the firm 3 years later after a billing irregularity that never became public. Danielle had absorbed it. That was the word she used, years later, in the rare moments she spoke of it at all. Absorbed, the way you absorb a blow you saw coming, the way you absorb the specific weight of being told, without anyone ever saying it aloud, that the room has looked at you and decided what you are. She had absorbed it and she had gone on, because going on was the only direction available, and she had built a career the way certain people build stone walls, slowly, deliberately, with pieces chosen and placed so carefully that when the wall is finally done, nothing on this earth moves it. Law Review. A federal clerkship with a judge on the D.C. Circuit who described her, in a letter of recommendation he later called the easiest he ever wrote, as the finest legal mind to pass through his chambers in 20 years. 7 years as a federal prosecutor, where she built a conviction record in complex financial fraud cases that made defense firms quietly reshuffle their strategies when her name appeared on a filing. Then private practice, then a professorship, then the nomination, supported in a rare display of bipartisan agreement, by senators who agreed on almost nothing else, and then the confirmation, and then the black robe, and then 11 years on the federal bench during which the words "Judge Hayes is presiding" had become, in the legal community of that city, a sentence that made prepared attorneys sit up straighter and unprepared attorneys feel a cold sensation moving through their chest. Richard Ashford knew none of this, and the reason he knew none of it was itself a small masterpiece of arrogance. The case had originally been assigned to Judge Harold Brennan, a genial 71-year-old whom Ashford had appeared before a dozen times and considered, in his own private taxonomy, manageable. Ashford's team had built their entire strategy around Brennan, his known impatience with lengthy expert testimony, his tendency to split discovery disputes down the middle, his habit of nudging complex cases toward settlement. Then, 8 days before trial, Brennan had suffered a minor cardiac event, recovered fully, and taken his doctor's advice to accelerate a retirement he had been postponing for years. The case had been reassigned. The reassignment notice had gone out through the standard electronic filing system. Ashford's associates had seen it. One of them, a careful young woman named Priya Raman, had even prepared a briefing memo on Judge Hayes, her procedural preferences, her published opinions, her reputation for showing no mercy to attorneys who arrived unprepared. Priya had emailed the memo to Ashford 6 days earlier, flagged high priority. He had never opened it. He did not read memos from second-year associates. He had people for that, and the people he had were the people who laughed at his jokes. At 8:57 that morning, 3 minutes before the session was scheduled to begin, Courtroom 4B settled into the particular hum of a high-stakes proceeding about to start. The gallery was fuller than usual financial reporters, junior attorneys from other firms who had come to watch. A row of anxious executives from the defendant corporation, whose futures depended on what happened in this room. Ashford stood at the defense table arranging his materials with the theatrical calm of a man performing confidence for an audience, and he was still enjoying the afterglow of his own wit, still riding the small chemical reward of the laughter he had extracted from his associates, when he noticed that the woman in the navy blazer had not left the courtroom. She had walked to the front. She had passed the counsel tables, past the clerk's station, and disappeared through the door beside the bench, the door that led to the judge's chambers. Ashford registered this with a faint, dismissive flicker of curiosity. Clerks used that door. Interns fetching documents used that door. He returned to his notes. Priya Raman, seated at the far end of the defense table, had gone very still. She had seen the woman's face as she passed, and something in her memory had snagged, the way Alina's memory had once snagged on a face in the back of an airplane cabin, a photograph, a judicial portrait, the headshot that accompanied a profile in a legal journal she had read while writing a memo nobody opened. Priya reached for her tablet. She pulled up the memo. She looked at the photograph on its first page, and then she looked at the chamber's door, and then she felt her stomach drop through the floor of the courtroom and continue falling for several stories. "Mr. Ashford," she said quietly. "Sir, I need to tell you something right now." "Not now, Priya." "Sir, the woman who just walked past, Priya." He did not look up. He deployed her name the way he deployed most things, as an instrument of dismissal. Whatever it is, it can survive until the recess. Judge Brennan's replacement is some administrative appointee. This is a straightforward morning, and I need quiet. Some administrative appointee. That was the complete sum of Richard Ashford's preparation regarding the person who now held total procedural authority over a $200 million case, a phrase he had invented himself, based on nothing, and found soothing enough to repeat. Priya opened her mouth once more, calculated the cost of insisting against the cost of silence, and made the choice that junior people in the orbit of powerful people are trained by 1,000 small punishments to make. She went quiet. She would regret it for a long time, and she would also come to understand that the regret belonged less to her than to the machine that had taught her the silence. At 9:00 exactly, the chamber's door opened. The bailiff, a broad, unhurried man named Officer Dwyer, who had worked this courtroom for 16 years and had watched every species of attorney arrogance bloom and die within its walls, rose to his feet. He had been standing near the rear doors during Ashford's earlier performance. He had heard every word, the intern line, the coffee machine line, all of it, and Officer Dwyer, whose face gave away nothing as a matter of professional discipline and personal philosophy, permitted himself, in the privacy of his own chest, a single quiet note of anticipation. In 16 years he had learned that courtrooms, whatever else they were occasionally instruments of a very precise poetry. "All rise," he called, and his voice filled the room the way it always did, and 200 people stood in a rustle of suits and settling silence. "The United States District Court is now in session, the Honorable Danielle Hayes presiding." And through the door, in the black robe that transformed the navy blazer beneath it into a private joke only two people in the room fully understood, walked the intern. The silence that followed had texture. Later, people who were in the gallery that morning would try to describe it and would reach for the same comparison independently. The silence of an entire room watching one man's face. Ashford's expression moved through its stations in full public view, the blank instant of non-recognition, the flicker, the connection, and then the slow, gray, cascading arrival of comprehension, like a building superintendent watching a crack travel up a load-bearing wall. His mouth opened slightly. His hand, resting on his legal pad, curled. Judge Hayes took her seat, looked out across her courtroom with perfect, unhurried composure, and let her gaze rest on the defense table for exactly 1 second longer than comfort allowed. "Be seated," she said. "Counsel, good morning. I understand some of you may not have had time to familiarize yourselves with the reassignment." The morning that followed was not an explosion. That was the first thing everyone misunderstood about Judge Danielle Hayes, and the last thing Richard Ashford would ever misunderstand about anyone. There was no lecture from the bench, no pointed reference to the words she had heard in the aisle, no visible satisfaction. What descended on courtroom 4B instead was something far more devastating than anger, and it descended with the smooth, frictionless weight of a hydraulic press. It was procedure. Perfect, exacting, merciless procedure. "Before we begin," Judge Hayes said, opening a folder on the bench, "I've reviewed the pretrial filings from both parties and I have questions. Mr. Ashford will start with the defense. Your motion to exclude the plaintiff's forensic accounting expert relies on the Daubert standard, but your brief cites the Ninth Circuit's articulation. We are in the Second Circuit, counsel. Was that a strategic choice or an oversight?" Ashford rose. He was a man who had built a career on his feet, on the resonant baritone and the commanding pause, and he reached for those instruments now and found them strangely heavy in his hands. "Your Honor, the principles are substantially similar across. That was not my question. Was it a strategic choice or an oversight?" The pause stretched. 200 people watched the most expensive litigator in the city stand in the open ground between two words, both of which cost him something. "An oversight, Your Honor." "Thank you. Candor moves things along." She turned a page. "Your reply brief on the discovery dispute, footnote 14, characterizes the plaintiff's document requests as, quote, a fishing expedition unsupported by any good faith basis. Yet your own client produced 11,000 of those documents voluntarily in the parallel regulatory inquiry. Explain to me how a request is baseless when your client has already conceded its relevance to a federal agency." And this, the room began to understand, was what preparation actually looked like. Not the performance of it, not the theater of thick binders and confident posture, but the thing itself, a mind that had read every page, held every page, and arranged every page into a structure with no soft places to stand. She had been on the case for 8 days. She questioned like she had been on it for 8 years. One of the financial reporters in the third row wrote a single sentence in his notebook and underlined it twice. "She knows the record better than the lawyers who built it." Ashford's answers grew shorter. His pauses grew longer. Twice he turned toward his associates for a document, and twice the delay in finding it sat in the courtroom's silence like an exhibit of its own. Priya Raman handed him the second document with her eyes down, and in the privacy of her lowered gaze lived a complicated arithmetic, sympathy, vindication, and the memo, always the memo, the unopened memo whose first page had contained the sentence, "Judge Hayes penalizes unpreparedness above all other failings, and counsel should assume she has read the complete record." Across the aisle, the plaintiff's attorney, a quiet woman named Carol Jenkins from a firm 1/10 the size of Ashford's, answered every question put to her in clean, direct sentences. She was not brilliant that morning. She did not need to be. She was merely ready, and next to a man publicly discovering the dimensions of his own negligence, readiness looked like genius. At 10:40, Judge Hayes ruled on the morning's motions. She denied the defense's expert exclusion in a 2-minute oral ruling that cited 4 cases from memory. She granted the plaintiff's discovery motion in part, and here the lawyers in the gallery leaned forward. She ordered the defense to produce a categorical privilege log within 10 days, personally certified by lead counsel. Certified, meaning Ashford's own signature, under penalty of sanction, on every claimed privilege. It was a ruling squarely within her discretion, unremarkable in isolation, and every attorney in that room understood its meaning the way sailors understand a change in the wind. There would be no shortcuts in this courtroom. There would be no manageable judge. Every corner Ashford's team had planned to cut had just been welded shut, one ruling at a time, by a woman applying nothing but the rules. She recessed the court at 11:00. She had not once raised her voice. She had not once referenced the aisle. She did not need to. The story was already leaving the building in the pockets of 200 phones. The first post appeared at 11:22, while Ashford was still in the courthouse cafeteria failing to eat a sandwich. A first-year associate from an entirely different firm, who had been in the gallery to watch what was supposed to be a master class in high-stakes litigation, typed 41 words into a legal industry forum with a wide readership. Just watched a senior partner call Judge Hayes an intern to her face before session in 4B, told her the clerk's office was down the hall. Then the bailiff announced her. I have witnessed the end of a man. By noon it had been screenshotted onto 3 platforms. By 12:30 someone had added the name of the firm. By 1:15 someone else, one of the gallery reporters, working his phone with the joy of a man who had come for a fraud trial and stumbled into something far more human, had confirmed the quote with 2 independent witnesses. And the word sweetheart, the clerk's office is down the hall, began their journey into permanence. The legal community of a major city is, for all its size, a village. Villages have one currency, and it is talk, and by mid-afternoon Richard Ashford was the wealthiest man in town. He did not know this yet. He was in a conference room on the 40th floor of his firm's building, doing the thing he had always done after a bad morning, which was to redistribute it. The Daubert brief circuit error belonged, he announced, to the associate who drafted it. The document delays belonged to the paralegals. The certified privilege log was judicial overreach, possibly appealable, and someone should research that immediately. The room absorbed this the way the room always had, with nods and notes, and for perhaps 20 minutes the machinery of deflection ran smoothly, and Ashford felt the morning receding into the category of anomaly. Then Douglas Bell walked in without knocking. Bell was the second name on the letterhead, 72 years old, a man who had argued before the Supreme Court twice and had spent the last decade in the quieter role of the firm's institutional conscience, which mostly meant managing the damage caused by its institutional id. He was holding a phone, and on the phone was the forum post, and he set it down on the conference table in front of Ashford with the deliberate gentleness of a man laying down evidence. Tell me, Bell said, that this is not accurate. The room emptied without being asked. Junior lawyers have an instinct for load-bearing conversations. What passed between the 2 partners in the following half hour was later reconstructed only in fragments. The building's walls were thick, but its assistants were observant, yet the shape of it was clear enough. Bell had spent the lunch hour fielding calls. A client's general counsel had asked, with lethal casualness, whether the firm felt its lead partner could still effectively represent them before Judge Hayes. A reporter had called the firm's communications director for comment on what she was already calling the intern remark, and the managing partner of a firm they co-counseled with on 2 matters had sent Bell a single-line email that read, in its entirety, "Is this handled?" It was a misunderstanding, Ashford said. A joke. Lawyers have been ribbing each other in courtrooms for. She is not a lawyer, Richard. She is the finder of fact and law in a $200 million matter, and you called her sweetheart in front of the financial press. Bell's voice never rose. Men of his generation and stature had long ago converted anger into precision. And I have now read the memo. The one Ms. Rammond sent you 6 days ago. 11 pages. Her photograph is on the first one. There it was. Ashford opened his mouth to explain the volume of his correspondence, the impossibility of reading everything, the way seniority necessarily meant delegation, and heard, even as he assembled the words, how they would sound. Not like a defense, like a confession with extra steps. He had not failed to know who Danielle Hayes was. He had been handed exactly who she was in 11 pages with a photograph, and he had considered the source beneath his attention. The insult in the aisle and the unopened memo were not 2 mistakes. They were one mistake, wearing 2 costumes, the settled, unexamined certainty that people below him had nothing to tell him. Bell picked his phone back up off the table. The executive committee meets tomorrow at 8, he said. Bring an explanation, not the one you just gave me. The client heard about it the way clients always hear about disasters last, and from the internet. Meridian Capital Holdings, the corporate defendant whose $200 million sat at the center of the case, employed a general counsel named Sandra Acaffer, and Sandra Acaffer spent that Tuesday evening doing something Richard Ashford had never imagined a client doing. The math. Not the math of the lawsuit. The math of the lawyer. She sat in her home office with a legal pad and wrote it out in columns, because writing things in columns was how she had survived 22 years in corporate law. In the first column, the facts of the morning, lead counsel had publicly insulted the presiding judge, unprovoked, in front of witnesses and press, before the first word of a trial projected to run 11 weeks. In the second column, the procedural reality, every discretionary ruling for the duration of that trial, every objection sustained or overruled, every deadline extended or enforced, every ambiguity resolved one way or the other, would now pass through a judge who had every right to be scrupulously, perfectly fair, and no obligation whatsoever to be generous. Judge Hayes would never punish Meridian for its lawyer's mouth. Everything Sandra had learned in 3 hours of frantic research told her the woman's rulings were appeal-proof precisely because they were passionless. But trials are not decided only by rulings. They are decided by rhythm, by patience, by the 1,000 small permissions a courtroom's authority can grant or withhold, and Meridian had just watched its $1,100 an hour advocate set fire to all of it in the time it took to walk down an aisle. In the third column, Sandra wrote a single word and circled it: jury. Voir dire was scheduled for the following week. 12 citizens would be selected, and those 12 citizens would spend 11 weeks in a room where the central human dynamic, visible in every exchange, every ruling, every carefully neutral instruction, would be a distinguished black woman presiding over a case argued by the man who had called her an intern. The story was already everywhere. Jurors were not supposed to know such things, and jurors were human beings with phones. Sandra Acaffer had defended corporations long enough to know exactly how that current would run beneath the surface of the proceedings, silent and constant, for 2.5 months. At 9:40 that night, she called the chief executive of Meridian and said the sentence that, relayed the next morning to the 40th floor of Ashford, Bell, and Whitmore, did more damage than any ruling from any bench could have done. I think we need to discuss whether Richard Ashford can remain on this case. The executive committee meeting at 8 the next morning lasted 3 hours. Ashford arrived with the explanation Bell had demanded, and it was, by the standards of such explanations, competent, a mistake of levity, a misjudged attempt at humor, a man of a different generation, immediate willingness to apologize to the court through proper channels. What it was not, the committee understood within minutes, was relevant. The question before them was no longer what Richard had meant. Institutions in crisis do not adjudicate intent, they calculate exposure. And the exposure was arriving by the hour. 2 more clients had called with questions. A legal gossip site had published a story titled "The 11-Minute Interview." And this was the item that made the conference room go silent, because none of them had known about it. Danielle Hayes had never spoken publicly about her 1997 summer associate interview at the firm. She did not have to. The firm's own records did the speaking. A former recruiting coordinator, long retired and apparently unburdened by loyalty, had confirmed to the reporter that the young woman with the third-ranked transcript at Georgetown had been interviewed by Richard Ashford personally, for 11 minutes, and passed over for a legacy hire who later left the firm under quiet circumstances. The story wrote itself, and the story was no longer about one remark in one courtroom. It was about 19 years and a closed loop, and a man who had now dismissed the same woman twice, once with a rejection and once with a joke, without ever once seeing her. Priya Raman read the article at her desk at 11:00 a.m., and then did something she had been thinking about for exactly 26 hours. She forwarded her unopened memo, timestamp intact, priority flag intact, to the executive committee with a 2-line note attached. The note read, "Attached is the briefing memorandum on Judge Hayes that I prepared and sent to Mr. Ashford on the 4th, 6 days before the hearing. I am providing it so the committee has an accurate timeline. I believe accuracy matters here. 26 words. Priya had drafted and deleted 11 versions, some angrier, some safer. One that was 3 pages long and read like a resignation letter. One that was a single sentence and read like a surrender. She had settled on 26 words because 26 words was the exact size of the truth. She was not accusing anyone. She was timestamping. And in institutions, a timestamp is the most dangerous document there is because it converts a story into a record. The effect on the executive committee was immediate and chemical. Until that moment, a partial defense of Ashford had still been assembling itself in the room's corners. The reassignment was recent. Things move fast before trial. Any of us might have missed it. The memo dissolved that defense on contact. There it was in the firm's own system. 11 pages flagged high priority, subject line reading urgent, Judge Hayes reassignment. Briefing and recommendations, delivered 6 days in advance, opened never. The firm's own metadata testified that the knowledge had been placed directly in his hands and that he had declined to close them. One committee member, reading the memo's first page for the first time, arrived at the sentence about Judge Hayes penalizing unpreparedness above all other failings and laughed once, without any humor at all, the way people laugh at architecture. By 2:00 that afternoon, the decision had been made, though it took 2 more days to become official. Richard Ashford would step down as lead counsel on the Meridian matter, citing, the language was negotiated line by line, the client's best interests and the firm's commitment to the effective administration of its engagements. Carol Jenkins, the plaintiff's attorney, read the substitution notice when it was filed and permitted herself one long, slow sip of coffee. In her 16 years of practice, she had never seen the opposing lead removed before opening statements. She had certainly never seen it happen because of 11 words spoken in an aisle. But before the substitution was filed, there was one appearance left. The privilege log certification, the one Judge Hayes had ordered under Ashford's personal signature, came due that Friday, and professional obligation required him to stand in courtroom 4B one final time. The firm's crisis consultant had prepared him for it the way handlers prepare a witness. Say little, concede everything procedural, and offer the apology cleanly, without qualification, without the word but, which the consultant described as the syllable that turns apologies into accusations. The courtroom that Friday morning was fuller than it had been for the motions hearing, and everyone in it knew why, and everyone in it pretended otherwise. Ashford rose when his matter was called. People who were present said afterward that he looked smaller, though his suit fit the same as it always had. What had changed was not the man's dimensions but the room's, which no longer arranged itself around him. "Your Honor," he said, "before addressing the certification, I would like, with the court's permission, to apologize on the record for my conduct in this courtroom on Tuesday morning. My remarks were inappropriate, disrespectful, and unworthy of this court and of my profession. I offer no excuse for them. I apologize to the court without reservation." He had delivered it exactly as coached, but no context, no levity. The gallery held still. 200 people watched the bench, waiting to see what she would do with the moment, because the moment was hers now, entirely, to spend however she liked. A lecture would have been legendary. A cold dismissal would have been quoted for years. She could have taken the apology apart in front of the financial press with 4 sentences, and half the room was leaning forward hoping she would. Judge Hayes looked at him for a moment over the top of her glasses. When she spoke, her voice carried no more weight than it did when ruling on a scheduling motion. "The apology is noted and accepted, counsel. The court is confident it won't be necessary again." She turned a page. "Now, the certification. I have questions about categories 7 through 12. That was all. 10 seconds and the aisle was behind her and the record was all that remained ahead. Later, a courtroom sketch artist who had drawn 1,000 faces would say Ashford's expression in that moment was the strangest one of the week, not relief, not humiliation, but something closer to awe. He had come prepared to be destroyed. She had done something worse. She had moved on. Because there is no destruction so complete as the destruction of being unimportant to the person you spent 30 years assuming would need to reckon with you. Judge Hayes did not need to reckon with Richard Ashford. She had a docket. She had a $200 million case to try. She had on the desk in her chambers a stack of habeas petitions from a federal prison 200 miles away, some of which she would read that night on her couch with a cup of tea, because she read every one of them personally, because that was who she was and had always been. Richard Ashford was, at most, a Tuesday morning. He had wanted to be a mountain. She had made him a Tuesday morning, and she had done it without breaking stride. He walked out of courtroom 4B at 10:14 that Friday and did not return. The substitution notice was filed the following Monday. A younger partner named Elizabeth Chen took over the Meridian defense, a woman who had, notably, read Priya Raman's memo the moment it was recirculated, and who arrived at the next scheduled hearing with a briefcase full of the Second Circuit, and a manner of address so scrupulously respectful that Judge Hayes, ruling against her on a procedural point that afternoon, added a small note of praise for the quality of her briefing. The trial would go on for 11 weeks. Meridian would lose on the central fraud count and prevail on 2 peripheral ones. The judgment would eventually settle at $94 million, and Sandra Acaffer would spend the following year rebuilding her company's compliance architecture with a diligence that was, in its way, the case's most valuable outcome. But that was the surface of it, the visible ledger. The deeper cost, the one that unfolded over the following months in ways that were harder to measure but not harder to see, was borne by a firm that had believed, without examining the belief, that its senior partner's judgment was worth more than the memos of its associates. 2 clients moved their portfolios within 30 days, one of them explicitly citing the reputational exposure of the Hayes incident in an email whose contents leaked, because such emails always leak. A recruiting class the firm had considered locked evaporated in a single week, when 3 top-ranked candidates from 3 different law schools quietly declined their offers. The firm's summer program the following year received the lowest volume of applications it had seen in 19 years, and the diversity metrics that its recruiting committee had been massaging for a decade collapsed on public dashboards that were, suddenly, being read. Douglas Bell, who had spent much of his late career as the institutional conscience, spent much of his 8th decade becoming the institutional physician. He commissioned an external review of the firm's promotion and mentorship pipelines, an act that the executive committee had rejected 4 times in the prior 5 years, and now approved unanimously in a single afternoon. The review, when it was delivered 9 months later, ran 340 pages, and the sentence its authors placed at the top of the executive summary would be quoted internally for years. Ashford, Bell, and Whitmore has, for at least 2 decades, systematically underused the talent it has been given, and the cost of that underuse is no longer theoretical. Bell read that sentence 3 times, and then he called Priya Raman to his office, and he offered her a formal role on the review's implementation committee. She accepted. She was 30 years old. Richard Ashford did not retire. That was, in a certain sense, the small mercy the firm extended him. The door was not shown, exactly. He was given the honorific of counsel emeritus, a role invented for him during a Wednesday committee meeting and printed on a new business card by Friday. He kept his office, 1 floor lower, with a slightly smaller window. His billable hours dropped to a fraction of what they had been. He was not invited to pitch meetings. Junior associates who had once laughed at his jokes now stopped by his office out of a mixture of pity and duty and left after the socially minimum interval. He spoke sometimes of writing a book on the evolution of federal civil practice, and everyone nodded and no one asked to see pages, because there were no pages and everyone understood that there would be no pages. He was, in the terminology of the profession, still there. He was, in every other terminology, gone. He came to see Judge Hayes 6 months later. It was not, strictly speaking, appropriate. There were procedural pathways for such a meeting, and he had not used any of them. He wrote a letter. He sent it through her judicial assistant. He asked, in language he had drafted and redrafted for a week, whether Her Honor might permit him a brief private conversation, off the record, in her chambers or wherever she preferred, at any time convenient to her, for reasons he described as personal rather than professional. He said in the letter that he did not expect a response. He said he would understand any answer, including silence. He received a response in 9 days. The judicial assistant's email offered him a 20-minute window on a Thursday afternoon at 4:30, in chambers, with the understanding that the meeting would be purely personal and that no matter currently or foreseeably before the court would be discussed. He accepted within an hour. He arrived at Fort 25 in a suit that was slightly less expensive than the one he had worn in the courtroom, though he could not have said why he had made that choice. Judge Hayes's chambers were smaller than he had imagined, a working office, not a display, lined with the kinds of books that had actually been read, cracked at the spines, marked with small tabs. She was behind her desk in a plain black cardigan, the robe hanging on a hook by the door. She stood when he entered, shook his hand once briefly, and gestured him to a chair. "Mr. Ashford, Your Honor, thank you for seeing me." She let the silence sit. He had rehearsed this conversation for 3 months, and he discovered in the presence of the actual room that none of what he had rehearsed was going to survive contact with her. He set the folder he had been carrying on his lap. He did not open it. He looked at the edge of her desk. "In 1997, he said, "I interviewed a second-year law student for a summer position at my firm. I don't remember the interview. I know that. I've thought about the fact that I don't remember it for 6 months now, and I've come to understand that the not remembering is worse than anything I could have said in it. Because a person I did not remember has spent 19 years being a person I could not have imagined, and the reason I could not have imagined her is that I was not paying attention to her when she was standing in front of me. I don't know how to apologize for that. I don't think there's a form of words for it. I came here to say that I know it. That's all." He stopped. He had not looked up. Judge Hayes was quiet for what felt to him like a long time, though it was, by the clock on her wall, perhaps 20 seconds. "Mr. Ashford," she said finally, "look at me." He looked up. "I want to tell you something, and I want you to hear it because I don't intend to say it again, and I don't intend to say it publicly. What happened in my courtroom in June was, for me, the smaller part of this. The larger part was the interview in 1997. Not because it was worse, the interview was legal, and the courtroom remark was foolish, and by most rankings the courtroom remark did you more damage. The larger part was 1997 because 1997 is where the courtroom came from. You didn't insult a judge that morning because you woke up cruel. You insulted a judge that morning because you had been practicing not seeing me, and people like me, for so long that the practice had become the person. The remark was easy for you. That's what I want you to understand. It was not a lapse, it was a fluency." She let that sit. He did not interrupt it. "I'm not the one who can absolve you of that," she went on. "I don't have the authority and I don't want it. What I will tell you is that I believe people can change what they have practiced. I've seen it happen. It is slow and it is unglamorous, and it looks less like a conversion than like a very long habit of noticing. If you decide to do that work, you will not do it for me because I am not part of your life and will not become part of it. You will do it because it is the correct thing to do, and because at some point every one of us has to decide whether we want to be the person our worst 30 seconds suggested we were." She paused. "That is the entirety of what I have to say. Was there anything else?" He shook his head. He could not, for a moment, trust his voice. He stood. He said, "Thank you, Your Honor," and it came out steady enough. She nodded once. He walked to the door. His hand was on the handle when she spoke again. "Mr. Ashford," he turned. "Priya Raman," she said, "the associate who sent you the memo. She is going to be a formidable lawyer. See that the firm you built does not waste her the way it tried to waste me." He said, "I will." He meant it in the way that people mean things at the doorway of rooms they will never enter again. He closed the door quietly behind him. Whether he kept the promise is the kind of question that answers itself slowly, over years, in 1,000 small choices no one records. What is known is that Priya Raman made partner at Ashford, Bell and Whitmore at 34, the youngest woman in the firm's history to do so, and that during her partnership vote Richard Ashford, who had by then been diminished to a ceremonial seat on the committee, spoke twice, once to nominate her, once to describe her judgment on the Meridian matter as, quote, the finest example of associate initiative he had witnessed in his career, unquote. It was, several partners noted privately afterward, the first time in a long time that anyone had heard him praise a person he had once dismissed. Whether it was the beginning of a habit of noticing or merely a single unusual sentence delivered in a boardroom, no one in that room could yet say. Judge Danielle Hayes never spoke publicly about the meeting in her chambers. She never spoke publicly about the 1997 interview either, though a legal historian working on a profile of her 3 years later would ask, and she would say only, "Everyone has interviews they don't get. Mine turned out to be useful information." She left it there. She continued to preside. Her docket continued to move with the terrifying, unshowy efficiency that had come to define her, and the attorneys of the district continued to arrive in her courtroom in the specific posture of the well-prepared, and no one ever called her sweetheart in an aisle again. The Meridian case, when the appeal was finally resolved 18 months later, was affirmed in every particular. The Second Circuit's opinion described Judge Hayes's trial management as, quote, a model of procedural rigor and even-handed authority. Carol Jenkins framed the opinion and hung it in her small firm's conference room. She got a great many new clients that year. Elena, no, that was another story, another cabin, another woman who had done the correct thing at the correct hour of the morning and been offered a door because of it. The parallel is not accidental. There is a shape these stories take when you watch enough of them. Somebody in the room sees. Somebody in the room writes it down, or sends it, or timestamps it, or refuses to laugh, and the record they create is what allows the correction, when it comes, to have edges. Priya Raman's 26 words did not, by themselves, remove Richard Ashford from a case. But without them, the removal would have been slower, softer, easier to survive, and the memo would have remained the private property of a woman who had done her job and been ignored for it. Instead, it became evidence, and evidence is the substance from which institutions are, very occasionally, forced to build something better than what they were. The lesson of that Tuesday morning in courtroom 4B, if it can be reduced to one, and reductions are always partial, was not that pride precedes a fall. Everyone knows that already, and knowing it has never once, in the history of pride, prevented a fall. The lesson was smaller and stranger. It was that respect is not something that begins when the badge appears. It is not something owed to the robe or the title or the corner office. It is owed from the first second to every human being who walks into any room, because you do not know who they are and you do not need to. The knowing is not the point. The seeing is the point. And the world, for all its speed and cynicism, still occasionally arranges itself into rooms where the failure to see becomes suddenly, publicly, and beautifully impossible to ignore. If this story moved you or made you think of someone in your own life who was seen or refused to be unseen, take a moment to like the video, share it with a friend who needs to hear it, and subscribe for more stories like this one. Leave a comment below and tell me, have you ever watched someone underestimate the wrong person? I read everyone. Thank you for being here. I'll see you in the next story.